Wow, we're already on chapter 5. I can't believe it. Things are going by so quickly. And we're only going through, till chapter 17. So it's like, wow, we've almost finished a third of our total chapters. So if you're still with me, way to go. Awesome. Okay, one of my biggest pet peeves, and that I love to test on, I've mentioned this before, but it bears repeating, is comparing civil cases to criminal cases and not using the wrong term for the wrong type of case. Okay, so in criminal cases, we're usually talking about breaking some sort of law, often a statute. The plaintiff is the government. It is not the victim. This is a very common misconception. And a case can even be brought if the victim doesn't want the case to be brought. Oftentimes it isn't, because if you don't have the victim's testimony, it's hard to prove a case. But it's really the people, the government, that is considered the plaintiff in a criminal case. And that's because we talked about before how it is a crime against our society, if you will. And so it's the government bringing it on behalf of all of us in the United States to help protect us and make us safer in the future. Also, we talked before, and we'll continue to keep talking about, it's beyond a reasonable doubt. You have to prove a defendant is beyond a reasonable doubt guilty. Alright, in civil cases, you notice I've got Lloyd versus Sullivan, because it's typically one person versus another person, or company versus another person. And people can represent themselves in civil court. This is known as in pro per, or they can hire attorneys to do it for them. And it's only a preponderance of the evidence. And if you remember that little scale I gave you, it was just slightly, 51% is kind of what the preponderance of the evidence is. One thing you might not know is that as an attorney, I'm supposed to actually research a case before I take it and make sure that there's some validity or merit to it. I used to love to go to the courthouse and file my own paperwork and stuff, because it was the only time I'd get out of the law office and see the daylight, if you will. And I had to stop going, because every time I got to the courthouse, I was just inundated by people that were vexatious litigants, unfortunately. There are a lot of people hanging out at the courthouse. Like, for example, I had a homeless man, want me to sue another homeless man for taking the spot that he normally slept in. Well, unfortunately, this spot was in front of a business, and he didn't have any rights to it to begin with. So, this wasn't a case that I could actually take and help him in a court of law, even though, I felt bad for him and wanted to see him do well in life. It just wasn't something that was appropriate for a court system. Okay, so I've put some websites in the extra materials for our last class about investigating people and claims, and one of them is People. So please look at those and check out your friends and neighbors and yourself and see what the dirt is. Okay, when we finally get around to doing the complaint, we've made sure there's a cause, we've made sure that there's a legitimate thing that the court can handle. We have to come up with causes of action. These are things that the law determines we can receive money for, somebody can be put in jail for. For example, we've got negligence. Negligence is an accident. You have a duty to other people not to injure them. You breach that duty. It causes damages to somebody else. That's something that a court can provide a remedy for. All right. Now, this is something I personally do before I sue. Your book mentions this after the complaint, because sometimes we can't get this information until after we filed a complaint. I try to do a little bit of research before I filed the complaint, because there's really no point in suing somebody who doesn't have money or insurance. And oftentimes people won't have money, but they'll have, an asset like a car or a home that they would have insurance for. So that insurance might cover the lawsuit. All right. General damages are known as pain and suffering damages. Okay? You can get money in a civil court for your pain and suffering. But how does somebody prove their pain and suffering? If it's an injury that someone can see from the outside, that makes it a lot easier. If it's like soft tissue damage, that's harder to prove. But, how much medicine somebody took, like pain medication, could help prove how much pain they were in. If it was an injury that was known to cause a lot of pain, that could help somebody get money for that. I also ask my clients a lot of times to do a pain diary. So they actually write down, often morning, afternoon, and evening, what their pain level is on a scale of 1 to 10, and do that on a daily basis, sometimes for months. All right, special damages are losses that are particular to a plaintiff. And again, we're talking about civil court right now, okay? If you remember, the chapter is about evidence investigation in civil and criminal practice, and right now we're talking about in civil court. So these are losses that are particular to a plaintiff, okay? She went to Dr. Thompson and had a $250 bill. Okay, another plaintiff maybe wouldn't go to that same doctor or have a $250 bill for that. So it's things that usually the plaintiff has receipts for. And I've given you an example of a spreadsheet that we do often allow to kind of keep track of, the amount either the client's paid and or the insurance company has paid. There's a third type of damages in civil court that spans kind of between civil and almost goes into criminal, because it's punitive damages. It's to punish the defendant, to deter them from doing this behavior again. And one of the cases I am proudest of working on is the Carrie Greenleaf versus United States of America case. And what this was, it was a doctor that basically would not treat an African American woman because she was African American, and we could prove it. And so we got the largest jury verdict at the time against a governmental agency, and you can see that was $2.8 million because the baby was born brain damaged because this person was racist. So when something is that egregious, like somebody won't treat somebody else, they're a doctor and they won't treat somebody else based on the color of their skin, then it is potential for punitive damages, because we want to deter that behavior as a society. We want to make sure that doctors, especially Naval Hospital doctors, are treating all the patients that they should be treating that come to them, So that's why the punitive damages were awarded in that case. All right, you'll have to use your regular PowerPoint to do this internet. So you won't be able to access it from this audio. All right, drafting a complaint, okay? The plaintiff does it with all the causes of action, talks about how much money they want and the prayer for relief. At the very beginning of the complaint, they have general allegations. Plaintiff is a person that lives in San Diego County, kind of thing. So general allegations, causes of action, prayer for relief. The complaint has to be served on the defendant, and there's certain ways it has to be served on the defendant. We get into that much more in civil litigation because paralegals in charge of making sure that complaint gets filed. I know a lot of you aren't going to be paralegals, and that's fine. So I won't get into too much of that nitty-gritty right now. All right. So in civil cases, the plaintiff is the person that brings a lawsuit, and the defendant is the person whom the suit is filed against. And we talked about the Plaintiff is a person or company typically, and the defendant is a person or company. All right, defendant's answer. Now, defendant doesn't have to actually answer. He could not answer at all. We talked about that before. He could also contest the complaint, but if he does answer, he needs to deny each and everything in the complaint. So any and all facts that aren't true, he needs to deny. He needs to deny being responsible for whatever plaintiff's civil complaint is about. And he needs to, in his prayer, ask that the plaintiff not get any money for this civil complaint. Now, when the defendant denies stuff, he does this really broad general denial where he denies everything all at once, and then he'll go back and specifically deny things. There's also affirmative defenses, which says, okay, even if I did do this, I was privileged to do this. For example, self-defense. All right, discovery. This is when we have the power of the court behind us as attorneys and paralegals to ask the other side for questions about the lawsuit and find out information. First one we have in discovery is a deposition. This is face-to-face with a court reporter there. It's under oath, so the power of perjury, a penalty of perjury applies. And these are expensive, but they're good because it's a way for the attorney to assess the witness or the plaintiff or defendant. It's also the only discovery that can usually be taken of a non-party, a non-plaintiff or defendant. Okay, and I've given you a little just diagram of what it looks like. Okay, interrogatories are written questions. So depositions would be the oral questions under penalty of perjury. Here's a sample interrogatory. This is actually a sample form interrogatory. We can ask special interrogatories, which are specific to that case. Okay, so we have the complaint, we have the answer, we have discovery, and then we move on to the trial of a civil case. And the plaintiff typically goes first in a civil case because they have the burden of proof to prove their accusations that the defendant is liable or whatever. And the plaintiff puts on the witnesses and evidence, and the defendant puts on his case, and then the jury goes back to deliberate. And here's one of the terms that you guys often get wrong on a midterm, and that is you say in a civil case somebody is guilty. No. Pet peeve, okay? In a civil case somebody is liable, so we're going to find them liable, okay? So please remember, civil case, liable, criminal case, guilty. All right. There's a difference between mediation and arbitration. Mediation is usually not binding, meaning somebody goes to mediation and they try to resolve it, and if they don't like the result, they can still go to court. Arbitration, typically the parties give up their right to go to court, and this is usually in civil. So the sides decide that instead of going to court, they're going to go to arbitration. Those of you who have Kaiser health insurance, you have all already agreed to go to arbitration and given up your right to a jury trial. And this isn't bad as long as it's a good arbitration or arbitrator that you're going in front of. In the legal community, we like JAMS and the American Arbitration Association. Okay, I'm going to end on this slide, but there are a few more slides for you. Remember, I only get 15 minutes per audio with Screencast-O-Matic. So oftentimes, even when the trial is over and the jury is deliberating, the parties will settle. And if they don't, then the jury comes back with the settlement that the defendant might have to pay in a civil court. All right. Any questions, comments, concerns? Please email me, call me, Skype me. Bye for now.